In the summer of 2015, a 93-year-old man was helped into a courtroom in northern Germany and convicted of being an accessory to the murder of 300,000 people. He had worked at Auschwitz as a young man, counting the money taken from the luggage on the arrival ramp. He was sentenced to 4 years. He never spent a night in prison because he died before the appeals were finished. He was one of roughly 7,000 members of the SS who served at Auschwitz and survived the war. Fewer than 800 of them ever stood trial anywhere, in any country, for anything. That is the story. Not the trials that happened, but the enormous number that did not. Auschwitz was not run by a handful of men. Across its existence, somewhere in the region of 8,000 SS personnel passed through the camp complex, along with a smaller number of female guards in the women's camp. They were guards, clerks, drivers, medical orderlies, dog handlers, block leaders, telephonists, and accountants. Some of them killed with their own hands, routinely and by choice. Others processed paperwork, and a system that murdered over 1 million people needed a great deal of paperwork. Most of them survived. They were young, they were not at the front, and in the final months, a large number simply took off the uniform, walked west, and joined the 12 million or so Germans moving across a ruined country with no papers and no fixed address. The first reckoning came from Poland, and it was the harshest one anybody faced. Poland had lost around 1/6 of its population and had the camp on its territory. It set up a national tribunal, and it extradited and prosecuted with real energy. Rudolf Höss, the commandant, was tried in Warsaw and hanged at the camp in April 1947. At the end of that year, a second trial in Krakow dealt with 40 members of the camp staff, including a later commandant and the senior overseer of the women's camp. 23 death sentences were handed down, and most were carried out early in 1948. Those two proceedings account for a substantial share of every Auschwitz staff member ever seriously punished. And they happened within 3 years of the liberation, before the political weather changed. Then the weather changed. By 1949, the Cold War had reorganized everyone's priorities. West Germany was being built into an ally, and the sitting judges, police officials, and civil servants of that new state were overwhelmingly the same men who had held those posts under the previous one. Prosecutors' offices were understaffed for this kind of work, and in many cases they were staffed by people with no appetite for it whatsoever. There was also a legal machine that worked against prosecution, and it is worth understanding, because it is the single biggest reason so many of these men died at home in bed. German criminal law distinguished sharply between the principal to a murder and an accomplice. To convict someone as a principal, prosecutors generally had to show that the accused had acted out of his own will and his own motives rather than carrying out orders. In practice, this meant that even at a death camp, an ordinary guard could argue that the murder was the state's, that he had merely assisted, and that the initiative belonged to Hitler and Himmler. That made convictions dependent on proving specific individual acts of cruelty. Prosecutors had to find survivors who could identify a particular man doing a particular thing, on a particular day 20 years earlier, among thousands of interchangeable uniforms in a place designed to destroy witnesses. Very often, they could not. And a technical amendment to the law in 1968 had the effect of running out the clock on many accessory cases entirely, which contemporaries at the time either did not notice or did not object to loudly. So the great majority of Auschwitz staff went back into ordinary life. They worked as clerks, drivers, tradesmen, and shopkeepers. They married, had children, drew pensions, and were remembered by their neighbors as unremarkable. The last commandant of the main camp, a man who had signed off on the operation of the gas chambers, was found in 1960 working as a forester on a private estate in northern Germany under an invented name. He was arrested and died in custody in 1963, before his trial could open. The women who worked there make up a separate category, and they were treated differently at every stage. Several hundred female overseers served in the women's camp at Birkenau. They were not members of the SS in the formal sense because women could not be, which created a technical argument about their status that was used in their defense afterwards. They were recruited from ordinary civilian jobs, given brief training, and given absolute power over prisoners. The most senior of them was tried by Poland and executed in 1948. A small number of others were tried by the British in connection with a different camp and hanged. but the majority were never prosecuted anywhere. Many were held briefly in internment, screened, and released, and they went back to civilian life in their 20s and 30s with an entire working life still ahead of them. Their obscurity is not accidental. Investigators in the 1950s and 60s consistently gave lower priority to female suspects, and courts that did try them frequently accepted arguments about their youth, their sex, and their subordinate position that were not extended to male defendants doing identical work. The one serious West German attempt to confront it came from a single official who refused to let it drop. Fritz Bauer was the Attorney General of the state of Hesse. He was a Jewish social democrat who had been imprisoned in 1933 and had spent the war in exile, and he returned to a legal system full of men who wished he had stayed away. He assembled the case that became the Frankfurt Auschwitz trial, which ran from December 1963 to August 1965. 22 defendants were tried. More than 300 witnesses gave evidence, most of them survivors, many traveling from Israel, Poland, and elsewhere, to describe in a German courtroom what had been done to them. The court traveled to the camp itself to establish sight lines and distances, because the defense disputed whether a man standing at one point could have seen what was happening at another. 6 defendants received life sentences, 11 received terms of years, several of them strikingly short given the charges. 3 were acquitted outright. It is worth knowing who some of those defendants had been in the years between, because the answer is the most disturbing part of the whole subject. One of them had been an interrogator in the camp's political department and had designed a device for suspending prisoners during questioning, which the prisoners named after him. He had spent the post-war years working in a factory in southern Germany, married, settled, unremarkable to his neighbors. Another had been a block leader who killed prisoners with injections directly into the heart. After the war, he worked for years in West Berlin as a hospital orderly, caring for the elderly and the sick on a ward. He was well liked. Patients are reported to have been fond of him and to have used an affectionate nickname for him. He was arrested at work. A third had run the disinfection unit and had personally administered lethal injections on a large scale. He had been living quietly as a tradesman. These were not men who had fled to South America or lived under invented identities in remote places. They had gone home, given their real names, taken ordinary jobs, and been absorbed without difficulty into a society that had every reason not to ask. Some of them lived within a short distance of people who had been in the camp with them. The trial changed West Germany, which was Bauer's actual purpose. It put the details in the newspapers every day for 20 months and made it impossible for a generation of Germans to keep saying they had not known the specifics. What it did not do was punish very many people, 22 defendants out of thousands who had served there. After that, for decades, essentially nothing. The men aged. Investigations were opened and closed for lack of evidence under a standard that could almost never be met. And then, remarkably late, the standard itself changed. In 2011, a court in Munich convicted a former guard at a different extermination camp on a new basis. The court held that the camps in question existed for no purpose other than killing, and that anyone who served there in any capacity had functioned as part of the killing machinery, whether or not a specific act could be proved against him. Service itself became the offense. That reasoning reopened files that everyone had assumed were closed forever, and prosecutors went looking for whoever was still alive. The results were the trials of the 2010s. The man who counted the money on the ramp, convicted in 2015 at 93. A former guard convicted the following year, aged 94 and sentenced to 5 years. Neither man served a day. Both died while appeals were pending. Later cases reached camp secretaries and teenage recruits who were tried in juvenile court because of their age at the time of the offense, in their late 90s. Defenders of those late trials argued that a verdict matters even when the sentence is theoretical, because it puts the finding on the record and gives survivors a court that says out loud what happened. Critics argued that convicting a dying man of something the state could have prosecuted him for in 1960, when he was in his 30s and fit to serve a sentence, is a performance rather than a prosecution. Both arguments are correct at the same time, and that is uncomfortable in exactly the way the whole subject is. Here is where it lands. Of the roughly 7,000 Auschwitz SS personnel who lived to see the peace, the overwhelming majority were never charged with anything. Something under 800 faced legal proceedings, and the large majority of those were tried by Poland in the first 3 years after the war. In West Germany, the country where most of them actually lived, convictions across the entire post-war period run to a few dozen. The men who ran the largest murder site in human history were, statistically speaking, more likely to receive a pension than a sentence. Thanks for watching. If you want to know how the judges who sat on those cases had spent the war themselves, watch that story next. And if you want more forgotten aftermath stories from the Second World War, subscribe, and we will see you in the next one.